Doctor Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Doctor Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Welcome everyone to another of our monthly medico-legal CME sessions. Hope everyone is well tonight. Thank you for staying and watching this very interesting talk entitled the Personal Data Protection Act, or Pdpa 2010, and patient records. And I think it will be interesting because there may be many aspects of the Pdpa which will be relevant to our medical practice. So, please stay on and listen. And our esteemed speaker for this session is Miss Krishantini Sebastian Pillay. And Miss Krishantini is a lawyer who was called to the bar in November 1997. She's a partner of the firm of S. Krishantini and Company, and her areas of practice include insurance and reinsurance, professional negligence, and general civil litigation. Ms. Krishantini serves as an advocacy trainer in the advocacy training faculty of the Malaysian Bar. Okay, now before we go on to start her talk, I just want to cover some housekeeping matters. So this talk, you will be eligible for 1 CPD point if you watch it. And the way you claim the point would be by scanning the QR code, which will be displayed at the end of the talk and the end of the Q&A session. The QR code will be valid for 1 hour only, and you use the MMA app to scan this code. After the live stream is over, you can still claim CPD points, and for the doctors and dentists, this is how you will do it. At the bottom of the page, docs.my/medico-legal-CME, you will see a link to the CME module, applying MCQs, or a form link for the dentist. So you can use this to claim your CPD point, even though the QR code has expired. Okay, I'd like to encourage you all to use Slido for Q&A at the end of the talk. And you have Slido app installed. You can enter the code 3249696 in the app, and that will take you to the Slido session. Or you can scan this Slido QR code and it will take you to the web link for our session tonight. Okay. You can use YouTube live chat if you're watching this directly on YouTube. All right, so we will also entertain questions on the YouTube live chat. Just as a final quick reminder, we'll appreciate if you could subscribe to our channel so to stay informed of our future talks. So hit the like and subscribe button. Yes. Okay. And this is just to remind you, you can claim CPD points at the end of the session and even after the QR code has expired. And this is where you click at the bottom below the video. Okay, and we'll display the QR code in this page. All right, so without further ado, I'm going to stream Miss Chris Shantini's talk, and it was pre-recorded, but she will come on stage live after the end of the streaming to answer your questions.
Good evening to all participants, and thank you, Dr. Ellen, for having me here this evening. Today I'm going to talk to you about the Personal Data Protection Act of 2010 and how it pertains to patient records. So the objects of the Personal Data Protection Act is to regulate the processing of personal data in commercial transactions and to provide for matters connected therewith and incidental thereto. So what that means is the Act will determine how data is used and processed in respect of commercial transactions only. This Act came into force on the 15th of November 2013, and it's a 2010 Act. Now, the application of the Pdpa, for short, Pdpa 2010, is found in Section 2 of the Act. And it's intended to apply to any person who processes and any person who has control over or authorizes the processing of any personal data in respect of commercial transactions. So we come back again to the fact that the Act governs personal data used in commercial transactions only. So you can see that the application is wide. It's any person who processes or any person who controls or authorizes the processing. So the person who deals with the data and their employer or their ultimate person instructing. Also, for this Act to apply, it must be connected with the processing of data in Malaysia or by a person or entity established in Malaysia, whether that be a company, an individual, a society, an association, or if the person is not in Malaysia, but has a branch, office, or practice in Malaysia, then that person would be governed by that Act if they are processing data here or for use in Malaysia. So there must be a connection to Malaysia for this Act to apply. Now, the Act clearly says that it applies to commercial transactions. And this is defined in Section 4 of the Pdpa, which contains all the definitions, as any transaction of a commercial nature, whether contractual or not, which includes matters relating to the supply or exchange of goods or services, agency, investments, financing, banking, and insurance, but it excludes credit reporting agencies for a very basic reason, which is that credit reporting agencies must be able to give access to the credit status of a data subject. And that cannot be interfered with. The data subject cannot say, no, you can't display this, or you can't withhold the information on my credit worthiness. So those agencies are expressly excluded from the application of this Act. Now, non-application is who the Act does not apply to. And Section 3 of the Pdpa sets out who it doesn't apply to. And it's just two categories of people. That is the federal government and the state government. It does not apply to them. So mainly because the federal government doesn't process data for commercial purposes. The federal government is the entity that governs a sovereign nation. And it is done for the benefit of the people of that nation and not for commercial benefit. So federal government, state governments are excluded from the application of this Act. You cannot write to the state government and say, remove my data from your records. It does not work that way. Now, this Act, so the second part of the exclusion is it doesn't apply to the processing of personal data outside of Malaysia. So it comes back to that connection to Malaysia. So it can, but it still applies if it's processed out of Malaysia, but then further intended to be processed in Malaysia. So it starts, say, in the UK, the data is collected and gathered there, and then brought to Malaysia, and further information is added to it. So then it then becomes processed in Malaysia. So then the Act would then apply to the whole. So the definition of personal data also can be found in Section 4. And it means any information in respect of commercial transactions which A, is being processed wholly or partly by means of equipment operating automatically in response to instructions given for that purpose, is recorded with the intention that it should wholly or partly be processed by means of such equipment, or is recorded as part of a relevant filing system with the intention that it should form part of a relevant filing system. If you look at this carefully, you will see that A and B refers to processing through equipment, whether it be computers or a database, or even a cash registry is equipment that might enter data and process it. Part C does not relate to equipment. So that's a catch-all that would cover written documentation, where you have handwritten it and no equipment is involved. It's just something that's written down. Data can include photographs, equipment, a photographic device, an audio-visual device, a recording device, X-ray machines. All these are equipment that allows for the gathering and collation of data, of the data subject, who in the case of clinics and hospitals would be the patient. And this would relate to data identifiable, where data subject is identifiable from the information that's collated. So it becomes personal. You can identify who is being recorded, talked about in this data set, whether it's a photograph or notes or a recording. So then it is personal to that person. There are two categories, or rather there's a subset of personal data. Personal data is the larger body, which is all data that is specific to a person. Whereas there's a subset called sensitive personal data. And that's defined as any personal data consisting of information as to the physical or mental health or condition of a data subject, his political opinions, his religious beliefs, or beliefs of a similar nature, and the commission or alleged commission of him by any offense or any other personal data that the minister may gazette. So it basically means things that are very sensitive to a person: his medical health, his mental health, his personal relationships, perhaps, his political beliefs, his religious beliefs. All these are very sensitive to an individual. And of course, his criminal record or otherwise. This would fall into the category of sensitive data and has to be treated with more care than just general personal data. And when we speak of processing, the Act defines it as the collecting, recording, holding, or storing of that personal data, or carrying out of any operation or set of operations on the data, which would include organizing, adapting, or altering the data, retrieving or consulting the data, the personal data, disclosing it, whether by transmission, transfer, dissemination, or otherwise making it available to third parties. And finally, the alignment, combination, correction, erasure, or destruction of personal data. So basically, anything that is done with the information to put it into a database, to order it for ease of retrieval, to correct it, alter it, save it, delete it, take it to look at, to maybe, in the case of medical cases, you retrieve the records to assess the patient's condition, see how he's progressed. All of that is actually the processing of the data in any way that data is handled. Now, the Act has 7 cardinal principles. They are called personal data protection principles. and they apply to the use and dissemination and dealing with of the data. These 7 are the general principle, the notice and choice principle, the disclosure principle, the security principle, retention principle, the data integrity principle, and the access principle. They're all fairly descriptive of what each provision is about, and each has a section in the Data Protection Act with further information. So we'll go one by one into these areas. So first, the general principle. The general principle is simply this, that the personal data, other than this is the general data, the personal data of a person shall not be processed unless he has given his consent to the processing of that data. And in the case of sensitive personal data, it shall not be processed except in accordance with provisions of Section 40. Section 40 governs the use of personal data, and I'll come back to it in a moment. So on the use of the general data, you must get the consent. But if you do not get the consent, there's still certain situations where that data might be processed. It might be allowable even without the written consent of the data subject. The first, as you can see in Section 2 sub A, is for the performance of a contract to which the data subject is a party. So for example, there's a sale and purchase agreement, and obviously the land office has to deal, well, sorry, the land office, it doesn't apply because they're the government. But say the runner at a legal firm has to take the data and maybe give it to the land office. So he's in the private sector. He's there for a commercial purpose, which is maybe which is the fees of the law firm, the work they do for their client. So if that data is dealt with in the performance of the contract to which the data subject is either the purchaser or the vendor, then these people have the right to deal with the data within the 4 corners of that contract for that purpose. The other thing it is usable, it may be allowable, is for the taking of steps at the request of the data subject with a view to entering into the contract. So it's the steps going towards the contract. So coming back to that example of a sale and purchase agreement, the bit where maybe the agent is getting the purchaser and the vendor together, and they're exchanging information on who they are, where they live, maybe their background, basically their ability to enter into the contract. So that there will be personal information exchange at that point. So this allows for that, even without a written consent. Thirdly is for the compliance with any legal obligation to which the data user is subject. So that would be a statutory requirement, not contractual. So if, for example, reporting, say there's a statutory requirement for reporting, AMLA reporting, for example, AMLA being Anti-Money Laundering Act, lawyers have to report any suspicious conduct to the government. So that is an exception to the requirement for consent. Then there is, in order to protect the vital interests of the data subject. So in a situation where the data subject's interests are potentially going to be compromised, a person having the data can act on that data to minimize the damage to the data subject or to act in their best interests. E for the fifth for the administration of justice, obviously in the cooperation of any investigation, whether it be coroner's court, police investigation, or even a disciplinary inquiry. All these are in the interest of administration of justice. So those, for those reasons, it can be disclosed without permission. The exercise of any function conferred on any person by or under any law. Again, reporting is an example of the anti-money laundering. Personal data cannot be processed though, unless the data is processed for a lawful purpose. So these exceptions above, they have to be lawful. Say, for example, it's a contract. If the contract is illegal, you cannot then, you do not have the protection of the statute. You cannot process a person's data. So it is necessary, and it must be necessary and directly related to that purpose. Yes. So the second principle is the notice and choice principle. Basically, very quickly, there's a lot here, but what it really means is if you're collecting data, you inform the data subject that you're collecting them, for what purpose, how it will be used, whether it will be given to third parties and under what circumstances, and basically give the data subject the choice to agree to the processing of the data or to refuse it. So notice of the collection and intention to process the data and the parameters of that processing, while giving the data subject the choice to agree or disagree or limit the use of that data. And you will see that subsection 2 says that notice must be given as soon as possible and in any event before it's given to third parties when we're talking about processing of data and sharing with third parties. The third principle, the disclosure principle, is in section 8 of the Pdpa, and it's very simple. It says that subject to section 39, which provides the exceptions, no personal data shall, without the consent of the data subject, be disclosed for any purpose other than the purpose for which the personal data was to be disclosed at the time of collection of the personal data, or a purpose directly related to the purpose referred to in subparagraph 1, or to any third party of the class of third parties specified in paragraph 7(1)(e). So first, you cannot disclose data unless it was for the purpose for which it was gathered or directly related to that purpose, or it is disclosed to a party that's specified in 7(1)(e). 7(1)(e) is under the notification principle, where you notify the subject that you are going to disclose to these third parties. So then it's already informed to the data subject. The security principle, which is section 9 of the Act, it says essentially it governs the care and control of the data. You basically have to take practical and reasonable steps to prevent data being lost, misused, modified, or used in an unauthorized fashion, or prevent the giving of accidental access or disclosure or alteration or destruction. And the level of care that's got to be taken is actually determined by how sensitive that data is, what the consequences of a leak of that data would be. And you would have regard to where you're storing it, how you're storing it. You have to look at the security measures put into place and make sure that it is reasonable in all instances. So if, for example, we talk about the hospital's records, you have a lot of sensitive personal data that you've got patient health, mental and physical records in there. So you obviously would want a strong firewall whenever there's points of access to that data from external sources. You would want to have strong antivirus. You would want to have a good IT department which checks on the data to make sure it's always intact, not lost. You back it up to preserve that data. And sometimes in hospitals especially, it's always sensible to have external audits of your data integrity, the way you're storing and using data, whether it is safe from outside incursion. So the retention principle, that's at section 10, it essentially means that the processor, the person who has acquired the data, shall not keep it for any period longer than necessary for fulfillment of that purpose. So, for example, if you're given data for the purchase of a car dealer, he keeps that data for the purposes of selling that car, but he then does not keep it to use for other purposes like his marketing or his profit projections. If you want it for that purpose, you would then have to get the express permission of the data subject to keep it. Otherwise, once this transaction is concluded, their personal data, such as their IC, their address, their various their income statements, they would need to be destroyed. So that's the second step, which says the duty of the data user is to take all reasonable steps to ensure that all personal data is destroyed or permanently deleted if it is no longer required for the purpose for which it's processed. The sale of the car is over. You don't need to keep it. Of course, we all know that with new cars, you have not just the sale, you have the warranty period. So usually for 5 years, the car comes back for service, any problems comes back. So you really can see that the period for which that data should be kept is the 5 years of the warranty. But beyond that, there is no reason for that data to be kept, and it should properly be destroyed unless permission has been gotten from the data subject to maintain that record. The data integrity principle, which is in section 11 of the Act, states that the data user shall, which means it is obligatory, there is no running away from this, they shall take reasonable steps to ensure that the personal data is accurate, complete, not misleading, and kept up to date by having regard to the purpose, including any directly related purpose for which the data was collected and further processed. So what that means is the data must be accurate. And this is an ongoing duty. It's not a duty that's only on you when you collect it. If you continue to process the data, there's a duty to ensure that it is accurate. Insofar as you have the ability to assess the accuracy of it. If it is beyond your information or knowledge, then all that's required is that it is accurate at the time of collection. And the final principle, the seventh principle, is the access principle. And it is that a data subject shall, that means it's mandatory, it shall be given access to his personal data held by a data user and be able to correct that personal data where the personal data is inaccurate, incomplete, misleading, or not up to date, except where compliance with the request to such access or correction is refused under this Act. There are several exceptions. It's useful to have a look at the Act. I won't go into it here because we will then overrun our time. But essentially, they all tend to relate to whether the request for change to the data is genuine, made in good faith, and there's a demonstrable need for that correction to the data. Then we come to the data. One more thing. We spoke earlier of sensitive data and how it may only be processed under Section 40 of the Act. Section 40 of the Act requires anyone processing sensitive data, which included the medical health information and the mental health information as sensitive data. It requires them to get the express permission of the patient, of the data subject. Except, and there are exceptions, where the data subject himself has made that information public or taken steps to make it public. So then it no longer becomes sensitive personal data because they've made it public. There are several exceptions where it is necessary for a person to process the data regardless of consent. And there are several, but the one that pertains specifically to the medical profession is that the processing of data for medical purposes. Written consent is not required if it is undertaken by for processing of sensitive data, if it is undertaken by a healthcare professional. So doctors, nurses, pharmacists, radiologists, all the people who collate, prepare, and process the medical data of a patient, they fall under the exception of having to specifically obtain express consent each time they process the data. It also applies to persons who may not be medical professionals, healthcare professionals, but who have, in the circumstances, a duty of confidentiality, which is equivalent to that of the healthcare professional. Who would this be, you might think? Well, a healthcare professional, as we all know, are doctors, nurses, pharmacists, people with medical training of some form. But there are also people in the administrative side who do deal with personal data, clerical staff, billing staff, admin, on the admin side. So they are allowed to deal with this data in the giving of this service, this healthcare service, but they have on them the same duties then that the healthcare professional has. That is to protect the integrity and sensitivity of the data, and obviously not transfer it to third parties, but only use it for the purpose of that patient's healthcare, or perhaps for billing purposes if a bill needs to be settled. So we come now to the specifics of this talk, which is how patient records and the Personal Data Protection Act tie together. Whether all the 7 data protection principles are hard and fast rules on the medical and healthcare profession, or whether there are exceptions. You have already seen in our discussion before this that the Act itself provides for exceptions for the treatment of a patient. So it's already baked in to the Act, the exceptions to these principles, these 7 principles, where you are, for example, the confidentiality, the notice, the requirement for consent. It is not required of the medical professional every time they process the data, as long as it's in the pursuance of the treatment of the patient. Now, in the medical profession and the healthcare profession itself, there are specific acts and provisions that do guide this. You would have the Medical Act. You would have the Private Healthcare Facilities and Services Act and the regulations thereunder. You would have the guidelines by the MMC that are set out for the dealing with and recording of patient medical records. All these modify the 7 general principles as they are specific regulations, because the Data Protection Act applies across the board to anybody and everybody, because as long as it's a commercial transaction, it applies to you when you're processing data. And obviously private hospitals, clinics, those are commercial transactions. You are providing a service for remuneration. So the various acts limit the extent to which the Pdpa can be applied to patient records, but not all patient records, and we will come to that shortly. So let's look at the type of data that's collected and processed by hospitals, clinics, and medical facilities. The first, all facilities collect this, it's the biodata. The patient's personal information, their name, IC number, address, occupation, race, religion, phone numbers, family information, next of kin, and their emergency contacts, their office addresses even. All that is their biodata. The second part is the thing that comes to the heart of the treatment of the patient. It's their medical records. So you collect the history from the patient or their family members. Data is collected and processed when samples are taken, x-rays are taken, the lab processes it, the radiologist processes it, the diagnostic technician will process various things. And of course, you have the treatment aspect, the surgical and medical notes, the nursing notes, the medication record, the therapies, the physiotherapists, the equipment used, all that forms part of the medical records, the records of all this. Then, so you have the biodata, the medical, and then the third is the insurance or payment information, or what you would call the financial data of the patient. This can include his medical cards, his employee benefit schemes, the forms and questionnaires that might be filled out for insurance companies, credit card information or bank account details if there are direct transfers made. You would have all access to all this through the payment process with the patient. And of course, your invoices and receipts. So this is all data as well. And the fourth category is research data. And this data could apply to the gathering of data for teaching hospitals or nursing schools that may take the patient data for the purpose and use it for the purposes of developing their course of study, improving their medical services, developing the field and the treatments, and also for statistical purposes. So these are various types of data that is gathered by a hospital. It's not exhaustive. I'm sure you as doctors and dentists will have other examples that you could give me, and I would look forward to any input you have on this. So right. I came across this rather nice and simple definition of what patient information is in the Section 3 of the Traditional and Complementary Medicine Act of 2013. And if all this seems a bit unwieldy, this description is actually quite useful. It says that patient information means the personal data of a patient, and it gives examples, such as the name, age, address, physical and mental conditions, and financial information. So basically, what we've discussed earlier, the biodata, the medical data, and the financial data are all the personal data of the patient. And therefore, processing of it would, unless limited by either the Pdpa or other legislation, fall under the 7 protective principles of the Data Protection Act. Now, there are specific healthcare regulations on medical records. This is under the regulations of the private healthcare facilities and services that apply to private hospitals and other healthcare facilities, as well as medical clinics and private dental clinics. So there are 2 sets of regulations, but when it comes to the medical records, they are both identical. They may be in different sections of the regulations, but the wording is the same. So both regulations define medical records as the patient's medical records means documentation of services by registered medical practitioners, registered dental practitioners, registered nurses, registered medical assistants, technologists, or other healthcare staff, and made in accordance with Regulation 44 pertaining to medical, dental, or other healthcare that are performed at the direction of the medical, dental, or other healthcare provider on a patient. So basically, it is everything that the hospital staff and consultants do for the patient in their care, whether it is the giving of treatment, diagnostic steps, or recording of history or data. Now, Regulation 44, which governs the what constitutes a medical record, it specifies that there is a minimum amount of information that should be contained in the record, the medical records. And this is contained in the 6th schedule of the regulations for the hospitals and the 4th schedule for the regulations for the clinics. And it's as follows. It's a bit long, so please bear with me here. So the person in charge of the facility has to ensure that the records contain 5 categories of information. 1, A, the registration number. B, the patient's name, address, date of birth, and gender. C, the name and contact details of relatives or friends or legal guardians. D, the relevant clinical details of the patient, including, and then it's all the clinical aspects, history, progress notes, medication orders, allergies, current medication, pre-operative procedure assessment, results of the diagnostic test. Then the 5th part is what has to be contained is the procedural records, whether it be operations, procedures, anesthesia, and these would then constitute the consent form, the date of operation of the procedure, the names and signatures of the practitioners carrying out the procedure, the type of operation, the pre-operative procedure checklist by the nurses, the drugs administered and dosages, the record of monitoring data, record of intravenous fluids and blood or blood products administered, the operation or procedure room report, including operative findings, the final diagnosis by the medical practitioner or dental practitioner, and any notes regarding the outcome of any operation or procedure, and any complications. These are things that you as doctors and dentists and healthcare professionals deal with all the time. And it's there in the in the regulations of the Private Healthcare Facilities and Services Act, that this must be recorded. So then this being a specific act, it modifies the Data Protection Act, where you have to collect this data and keep it. And as long as the patient comes to you for treatment, his consent for the gathering of this would initially be taken when you initially see the patient and you're giving him the treatment options and all that, you're giving a consent. It's taken then, and then it applies throughout that treatment process without you having to go back to the data subject. And it continues to be incumbent on the hospital to preserve this data even beyond the initial consultation and treatment. So can a patient demand that a hospital or clinic delete, withhold, or seize the processing of medical records? In most instances, the answer would be no, because there are requirements, statutory requirements for the collection and storing of the data. For example, Section 67 of the Private Healthcare Facilities and Services Act requires the reporting of accessible debts to the government. So that's a statutory requirement. You don't require the permission of the patient or the family to do that. You must do it even against their objections. Then the Private Healthcare Facilities Regulation states that the medical records are the property of the hospital. So the patient can't remove that data or destroy it. The regulations further require that the hospitals must, at a minimum, maintain the records for any applicable limitation period. So generally speaking, it's 6 years with adults, and the age of majority plus 6 years for minors. But if a person is incapacitated, they have no mental capacity, perhaps a bad case of cerebral palsy or a person in a vegetative state, then technically speaking, there is no limitation period on any action by that patient through his representatives. So the best thing to do is keep that data for as long as possible, for the foreseeable lifespan of that patient, if possible. So essentially, the data cannot be deleted, amended, or expunged at the patient's demand, unless there's demonstrable evidence, meaning there's clear evidence that the records are wrong. In that instance, a correction can be made. But the interesting thing about medical data is, if a patient has told you they are allergic to a certain drug, and then they come back a certain next day and say, oh, they're not allergic, you don't go back and delete the earlier entry. You leave it there and just record that at the later state, the patient now tells me he's not allergic because, for example, he was administered this medication and he had no reaction to it. So you preserve the original information and the correction as well. Now, it is important to note that this protection of the records is in respect of statutory record keeping and the patient's medical records only, as these relate to the patient's treatment. If the data is being used for purely commercial purposes, for example, when the patient is being sent advertisements on elective or aesthetic treatments, the patient can demand that that contact cease and he be removed from any marketing lists, because these are speculative treatments for financial gain. They're not really about the necessary medical treatment. This is elective. It is aesthetic. It is not mandatorily required for the health and well-being of the patient, but it can be offered. So in respect of the withholding of data, requesting the hospital withhold the data, the patient can expect that the hospital, clinic, or medical professional will withhold the sharing of the medical information from third parties without his express consent pursuant to the confidentiality principle, except, of course, in conditions where there's a court order that requires that withhold sharing of data. So the patient cannot object to that, or in pursuance of a criminal investigation, or in relation to the medical treatment required by the patient, e.g. consultations with third parties, such as medical specialists who are not in that hospital. Now, lastly, can a patient demand access to his patient records? Generally speaking, the answer is yes, he can, pursuant to the access principle. There are, however, some exceptions. Now, in the case of Nurul Husna, Muhammad Hafiz, and another versus Kerajaan Malaysia and others, the court there held, Justice Wazir, as he then was, held that a court order is not required in order for a patient to gain access to his medical records. And he went on to say and discuss the exceptions. His lordship had had the opportunity of looking at the Private Healthcare, Private Medical Facilities and Services Act. He had the opportunity to look at the Medical Act and the guidelines issued by the MMC, and he came to this conclusion, as well as the case law. He studied the case law in Malaysia and various jurisdictions. And he said this, that the patient has an innominate and qualified right of access to his medical records. And there's a corresponding general duty on the part of the physician or hospital to disclose the patient's medical records to the patient, his agents, medical advisors, or legal advisors. The physician or hospital, however, may refuse to disclose wholly or partly the medical records in certain limited circumstances, such as, but not limited to, situations where the disclosure would be detrimental or prejudicial to the patient's mental or physical health, or that it would, or where that disclosure would divulge information relating to information provided by an individual other than the patient. For example, a concerned family member had provided information about the patient's condition, and the patient wants access to whatever has been said. If the healthcare professional is of the opinion that that is not appropriate to disclose to the patient, that can be withheld. Other exceptions are when it would, so except when something like that comes up, properly speaking, and if the request for disclosure is reasonable, and reasonable meaning that the patient may want, for example, a second opinion or want to consider legal action. Those are all reasonable reasons. But if it's a frivolous reason, the patient just says, oh no, I just want to see what you wrote, doctor. Can I just have a look? No, that's generally not a reasonable request. That's just being curious, and it's not relevant to the patient's well-being or health. So it could be a speculative request for information could be refused, but a request in relation to the patient's health, mental health, well-being, and rights, whether it be legal or personal, those should be properly entertained. So that brings me, of course, you're entitled to charge administrative charges for the provision of that copy. So that brings me to the conclusion of this talk, and I'd be happy to take any questions from you. Thank you all.
Oh, thank you, Miss Krishantini, for the excellent lecture. And I'd like to bring her on live to the stage and welcome Chris.
Hi, Dr. Allen.
Yeah, it was a great talk. Now, I'm sure there are questions, and there are already some. And maybe we'll address this first because we got about 10 minutes left. Let me share the one from there's one question in Slido and a few in YouTube comments. So if you can see, there's a question by Anonymous who asks if the patient has HIV/AIDS info and it's shared in a referral and there's leakage of this info from that end, is the I think it means referring doctor indirectly held accountable by the patient? So there was some sensitive health
Okay.
data and it was leaked in the
The
referral.
data has been given by one doctor to another doctor for the purposes of a referral. And what has happened is that the data in that second doctor's office has been leaked. The simple answer would be no. The first doctor who has given the data to uh, the referee doctor, the referring doctor is not responsible for leaks in the referee doctor's office, unless, of course, they are within the same organization. But if they are separate, say Pantai Hospital gives to KPJ Damansara, for example, Pantai Hospital can't be responsible for any data breaches in KPJ Damansara. It only works if they are part of the same organization, say a branch of the of the hospital.
Would it matter where the leak occurred, whether which end the leak, make a referral if somebody where it was intercepted at the beginning or the end? So whether
Okay.
the referrer or the referee.
Coming to the thing about the branch, it doesn't matter where. If it is a group with branches, a clinic with branches, it doesn't matter where the leak occurred. The company that runs the clinic would be responsible for the breach. But if they are separate entities, legal entities, separate individuals, maybe clinic A gives to clinic B, they are not owned by the same people, they are different entities, then where the leak occurred is where the breach occurred, and that is the responsible party. I hope
Okay.
that addresses it.
Let's moving on. We got a few questions, a series of questions from Dr. Aryan on YouTube. So I'm going to highlight that one below. So the PHFSA requires mortality review in a hospital. And under PDPA, can the case notes of an expired patient be shared with another doctor but not involved in the care of the patient for the purpose of review? Um,
Okay, if we are
so
talking
the
about an
patient has,
internal review, if you're talking about an
it looks like
internal
a,
review, yeah, of the yes, because you don't just have mortality reviews, you would have morbidity reviews as well. While that may not be statutorily imposed on you to do, it is good medical practice to have your own internal reviews of what may have gone wrong in patient treatment and care. So you are still doing it within the same organization. If you are talking about bringing in an external doctor to review, that can be done, but that doctor would then also be subject to the PDPA rules, meaning that that doctor cannot further disclose, cannot publish without permission and things like that.
okay. The key thing is same organization. So ethical
You
code of
can
MMC
bring
requires
in
yeah.
external doctors. You can bring in external
Mm,
doctors for the purposes of consultation, for the purposes of review. This is part of the medical treatment. But that external doctor, once he takes on that patient or takes on the responsibility for review, is also then comes under the umbrella of the requirements of the medical of the Private Healthcare Facilities Act and the PDPA, where the Private Healthcare Facilities Act is silent.
okay.
Yeah.
Ethical code of MMC requires patient consent for disclosure of notes, but there's no exception if required by law. Which takes precedent, ethical code or PHFSA?
Let me understand this.
Yeah.
Has patient consent for disclosure of notes, but there's no. I'm not quite sure. Exception to what?
Yeah. I'm not so sure either. We'll
I'm
skip.
not sure what the question is. Yeah.
Ethical code requires patient consent for sharing confidential. Which takes precedent, PHFSA or the ethical code? I think this.
This presupposes that the PHFSA prevents you from sharing confidential data. But I think it's important to ask sharing with who. If it is sharing within the same facility for the treatment of the patient, then it's all under the initial consent that was taken because you're all acting on his healthcare needs. This question probably needs further information. Sharing with whom? That's one.
Okay.
Is it with the patient? Is it with his representative? Is it with third parties? More information is required for this question.
Okay. Let's move on. And Dr. Ho asked, if the patient asks for a record, can we not allow them to photocopy the notes but instead write a report?
So you don't want to give them the notes, you just want to give them a report.
I mean, can we just photocopy and pass it to them?
Oh, the question is, can you photocopy? If they ask for a report, give them a report. If they're asking for the medical notes, then they are probably considering legal action because they're not really interested in the notes unless they want to consider legal action, or they want a second opinion. They will tell you their purpose usually. You give them a report when they ask for it, and you give them the notes when they ask for it. But again, it comes back to whether it is a reasonable request or whether it's speculative. If it's speculative, you're not required to give the patient this simply out of their curiosity they're asking. But if they're asking for referral purposes, second opinions, or if they want to take legal action, what is the purpose of withholding it? Because if you withhold it, they will go to court and then you'll still have to give it. And that Nurul Husna case also does say that there's no reason for you to withhold it if they're asking reasonably. There is a school of thought that refers to Section 44 of the Regulations of the Private Healthcare and Services Act, which talks about the medical record not being taken out of the hospital. So some maybe some hospitals rely on that to say, no, I can't give it to you without a court order. Now, my view of that, and I think it is also echoed in this it is set out in Nurul Husna's case, is that the medical record refers to the original documents, whether it be the data in the hospital's MRI machines or the actual handwritten notes. Yes, those should not be taken out of the hospital without a court order. But photocopies, these are copies. There's nothing preventing a copy being given to the patient if they ask for it for a reasonable request, not just for fun. So yeah, the patient is allowed to get whatever they ask for, provided it's reasonably requested.
Okay. I have a question myself before we go on to a few other questions in our comment section. And, I suppose every clinic and hospital falls under the Pdpa because of there is service and commercial transaction at least in the private sector.
Yes.
Is there still a compulsion to register as a Pdpa user? Because I remember at the beginning, all the clinics have to register, and you pay something to register to be it's very strange. You actually have to register to be a user to follow the law. Is that still applicable? And because there's some doctors in our community who ask, oh, I previously registered, but I never renewed. You're supposed to renew every year
That's
as
a
a
good
registered
question. I
user.
will need to get back to you on that because the fact is everybody gathers data, but they are limited by the Act. I think what you're talking about is when you have online a central data gathering and processing system. But if your records are just paper records, I don't think you're required. But I will put a pin in that because I'm not entirely certain the context
So
in
there was
which.
an organization. I mean, at the beginning, we had to register as a data user, and you have to pay an annual fee for a few hundred ringgit, and the registration is valid for 10 years, and then they issue a certificate. So this is one, to me, rather strange instance where we can comply with the law, but we also have to register with some organization
But that
that we
is,
are a PDPA user. Sounds smacks a little bit of rent seeking to me. I mean, we are a
yes,
bit strong, but
I'm sorry, that's not something I have had to deal with. I
yeah,
can't give you a straight answer, but I will certainly look into it and give it to
mm,
you later, and perhaps you can
yeah,
share it with me.
okay.
Yeah.
Um, does the PDPA also come under? I mean, same thing for medical societies, associations, alumni, and all that. We process
Um,
members' data. Does that fall under the
Interesting question
PDPA?
though. Is it for commercial purpose?
Maybe the only commercial thing is maybe they collect membership fees. Is that
Okay. It's not technically a commercial purpose.
mm,
However, um, to be safe, I would comply with the PDPA guidelines
yeah,
because at the end of the day, you're
okay.
collecting membership fees. So it
Mm,
can be loosely interpreted to say, well, yes,
okay.
you are collecting money to run your organization. So yeah.
Okay. Let's move on to questions from the floor. John Doe, emerging technologies like blockchain have been proposed as solutions for enhancing data security and patient control over the records. How does the Act adapt to address the unique challenges and opportunities? And I mean, this is enhanced security of data. I think it's very good. In fact, I did
Yeah,
before
because
the talk ask you.
blockchains
Mm,
are distributed all over the world.
yeah.
But it's still processed for use in Malaysia or processed through Malaysia. The
Mm,
Act only governs the processing of
mm,
data in Malaysia. So at some point, that data is going to get accessed for use in this country.
mhm.
If you're a medical healthcare professional, you are going to use it in Malaysia, regardless of where you store it. So the Act, as it is worded, actually does cover this. Um,
Okay.
I
In the transmission of unencrypted data like email, say the patient requests e laboratory data email to him or her, uh, does that fall afoul of the PDPA because it's not encrypted and not secure?
um, no,
Does
because
that
you're giving
be
the
some level of
patient.
security? Yeah,
Yes,
to
of course, you don't, you would, I mean, some basic precautions should be put in. Preferably, if the patient, is overseas and can't come and collect the report or lives
mm,
very far away, it could be transmitted by email, but try and impress upon the patient that you need to encrypt it to be safe. But sometimes the patient is not tech savvy and is not
mm,
able to open a document and says, "Doctor, just send it to me unencrypted." As long as he gives you that permission to do so, and you've got an
mm,
email saying, "Yeah, please send it to me, just unencrypted," and he confirms that that is his email, I don't see a problem because you are giving it directly to an address that he's asked you to
yes.
send it to.
To me,
It's
it
posting
goes
to him.
directly to the recipient. I mean,
Yeah,
we are not controlled whether if somebody hacks his email address or another relative
exactly,
looks into
exactly.
his,
It's the same
that
as
is not
sending it in
our
the post.
issue, isn't it?
Yeah, it's the
Yeah.
same as
Okay.
sending it in the post. You're sending it to the
Mm,
address he wants it sent to.
mm,
As long as
mm,
it is sent to him at his request through a medium that he has requested for, that would be fine.
mm,
An email
mm.
is relatively safe. I do have reservations about sending it as an attachment over WhatsApp and things like that because that WhatsApps are so easily, I mean, you're
Yeah.
giving that information to WhatsApp because most things are not encrypted with them. So, but emails are
Banks
generally.
banks
Sorry?
which handle financial data also email, let's say, statements, but they password protect it or something
Correct.
as a PDF.
Yes.
Yeah.
Yeah. Something can be done
Okay.
to that in that way.
Okay, let's move to the next one. Can you elaborate on the legal and ethical consideration when it comes to storage and management of genetic and genomic data, given its highly sensitive and predictive nature in terms of health risks? I'm not sure about the highly sensitive, yes, but predictive nature, not so sure. But anyway, it is sensitive data. So if
Yeah,
somebody
because
does, yeah,
the gene is
DNA
specific to that
analysis and all that,
person.
yeah.
So yeah, you still come back to the security principle where it must be stored. Reasonable precautions must be taken for the integrity of the data to be kept, not disseminated to third parties. So it's really the security, the firewalls and the software protection that you put in to your system that would determine whether you have satisfied that security principle.
Okay,
It's a very general question, so I'm not quite sure what's wanted here. Yeah.
What are the legal? We will move on because I think it is sensitive data, so I guess it is covered.
Yeah.
What legal remedies are available to patients in cases of data breaches involving their medical records? So, how does the Act ensure that individuals are adequately compensated for any harm caused by such breaches?
Okay, the Act doesn't provide for
It seems
compensation,
to
but
punish the data user, but
what
what
happens is I think
compensation?
they have enforcement provisions where
Mm,
fines can be imposed and things like that. But that is between the enforcer and the data user. But what the individual has is a common law right to sue
okay.
for
Mm,
negligence. And that negligence can be proven because the Act sets out a standard for the usage and protection of data. If you breach that, then the patient has a common law right to sue for damages and injunctive relief, perhaps, to prevent further breaches. So, yes.
Just on the side, it's quite ironic when, say, hospitals, clinics, we have to be very careful with the data, keep it secure and everything. And then we read of millions and millions and millions of Malaysians have their personal data breached by hacking of government agencies or corporates, so our mobile numbers, names, everything has been leaked and for
Sadly,
sale.
the Act does not
So
apply
it's
to the government.
yeah, so much for the Pdpa when the government
Yeah.
is not liable. Anyway,
No, it doesn't
in the
mean the
context of
government's not liable. Sorry,
international,
doctor. It doesn't mean the government's not liable. If they've had data hacked and you have suffered actual loss, so your bank accounts have been wiped out or
mm,
something like that,
mm,
you can sue the government for negligence. It's a common law right. You don't even have to look at the
okay,
Act, but you can't
okay.
take the Act and penalize the government or things like that.
Mm,
So, yeah,
mm.
that's fair.
In the context of international data transfers, how does the law address the challenges of maintaining data protection with patient records
Sorry. In the
in
context
with
of
respect to
international data
different jurisdictions and
protection of
differing
this
privacy regulations?
patient records.
But it doesn't apply, isn't it, if it's not in the
It
country?
talks about the processing of data in Malaysia. If someone is accessing it outside Malaysia, and these are databases that are outside Malaysia, this Act would not apply. But if it is a database in Malaysia, which is providing access to third parties, then it is being processed electronically in Malaysia for access overseas. So the Act still applies. The protective principles, the right of access, the right of the security principle, the retention principle, all of that still applies. It's just whether it is just passing through Malaysia or actually stored in Malaysia for access. If it's stored in Malaysia for access, it is being processed in Malaysia. So it would fall under the Act.
There's another pertinent question from John Doe. Could you discuss the challenges in enforcing the PDPA when dealing with medical data stored on personal devices, which is not in the
First of
direct control of
all,
healthcare
why is the
institutions?
medical data on a personal device? Whose
Yeah.
personal device? If it is the
Okay,
patient,
let's
that's
say
a problem,
the
right?
doctor, all right, keeps patient contact on his phone for the purpose of sending a WhatsApp to the patient, or
Oh,
WhatsApp communication, but the
okay,
patient data is on his phone. Is that allowed? What if his
okay.
phone is
Few
lost and
things
then
here.
somebody else accesses and say, "Oh, I've got this doctor's contact, and these are all his patients I can see."
Right. Few things first, right?
Mm,
One is when the exchange, there will be an exchange of phone numbers, right? When the
mm,
patient gives the doctor the phone number, that is the patient giving the doctor permission to have his phone number. And so that allows you to keep it in your device, the phone number, for the purpose of communication. Mr. Low, could you please come in? You are not, you've missed your appointment. That kind of thing is fine and dandy. That's all right. Storing medical records, however, like reports, test results on the doctor's personal phone, I would say is a no-no. If it is got to be, I mean, the patient is like in the remote wilds of somewhere far away, and the only way the person can communicate is through WhatsApp, and I would be surprised they have access to WhatsApp, but never mind, for the purposes of discussion. You can only send it through WhatsApp, and the patient says, okay, please send it to me through WhatsApp. You get that permission. There should be then a device owned and maintained by the clinic for that purpose. And it stays in the clinic. It doesn't leave the clinic. It's not taken home. It's not used for personal calls. It is just for that purpose. If you are going to do this, I would strongly recommend against it, but sometimes there's no choice. And I have seen that clinics, law firms, they have office phones that are used for specific things. Like in the case of law firms, we might use a specific phone just for the e-filing, or something like that. So you can do it, but there's no reason for any healthcare professional to have patient data other than their phone number on their phone. Yeah.
Dr. Kuharaj has a comment that the Nurul Husna case was against a government hospital, so the PHFSA does not apply. Do you want to comment?
Okay. No. If you look at that case, the judge did actually refer to the Private Healthcare Facilities Act and Regulation 44, and he said that he doesn't see Regulation 44 as grounds for which to withhold records.
And it says, quotes this section, no medical records of the patient shall be
Okay.
taken out of the
Yeah,
clinic
this
without
is
a
where
court
I
order.
would come back to the fact that the medical record is the original. It is your handwritten notes. It is your data on the drives. There's nothing to prevent copies being made and given to the patient. So I think that is a rather unreasonable interpretation of the act, because the medical record is the record. It doesn't say copies of medical records. If it said no medical records or copies shall be taken out, I would then agree, yes, you couldn't do anything without a court order. But here it just says medical records. So I would read it in a sensible fashion to refer to originals. But if if a hospital wants to be extra careful and ask for a court order, by all means ask for it. And then when it comes to court, you say no objection and hand it over. Why are you wasting time? I don't know.
Okay.
Yeah.
Sorry,
So,
we are about 15 minutes past time already. Sorry to keep you. You've been very kind to answer our questions, Chris. We I think we're reaching the conclusion of the session. So thank you for everyone for listening and joining in. Please don't forget to hit the subscribe. Okay, I know you're anxious to get the points. If you have caught this video past our live stream time, let's say if you're catching it tomorrow, you can still claim points. So just below the video in our page, there's a link to the CPD points module for doctors and the registration form for dentists. All right. The moment where all the doctors are waiting for, you want to scan for. This is how we get points. I think lawyers don't need to get CPD points for annual practice. Yeah, I
Not
believe.
mandatory, no. We pay fines though if we don't get our points.
Yeah. But I'm curious to know, there is I will share that link page. You have to register to be a PDPA
I'll take a look at that
user.
and get back to you.
Yeah. And a lot of people seem to have forgotten about that. And then your registration has an expiry period,
Yeah.
which is a concern. Let me see. Oh, let me close this one. It's blocking the QR code. Sorry. Okay. Should be able to scan now. Okay. I hope everybody got their point. Okay. I'm just going to move away just quickly to show the the pdpa.gov.my website about user registration. And I don't know how it spells out in Act and what are the consequences if we don't register. But we say we follow the Act, we obey the law, but we didn't register as a user. What are the consequences? Is that
Oh, perintah
under
golongan
the
pengguna.
mm,
Okay,
mm,
there is a category of users.
mm,
Okay, let me see if I can find that actually.
under pdp.gov.my, the official portal of the Department of Personnel. I
Yeah, I
mean,
think I
to
will
me,
have a
a
look
lot.
at that.
Yeah,
I'll have a look at that and get back to you. It may not apply to
yeah,
everybody because it seems to be a
yeah,
category of
yeah,
users. Yeah.
yes. I'm not sure. Yeah, but I know of
Mhm.
previously when it came out, then some doctors who were, had running clinics, they registered.
Mm.
Then it came out after years later. Hey, we didn't. We knew what is happening. Or some new clinics may not have been registered, and it goes for medical societies as well. I don't know how many actually have registered. If they are engaging in commercial things, maybe they run seminars where people pay to participate and things like that. So that to me it's
Mhm.
maybe a commercial transaction. I'm not sure, but how many have registered for the PDPA? Yeah. Well, to me, it's strange again. Like it's a law where you comply, you follow, but yet you have to be registered to be a user of the law. Now, if you have
Mm.
to register to be a user of the law for all the laws in the land, I think there'll be no end to red tape. But I think
At
with
least
with
that's for
that,
tax purposes, but this is not a tax, so I'm not quite sure. Yeah.
yeah. Okay, so Chris, thank you once again, and I think we have to call it a night. And the QR code will still be valid only for another half an hour, so you guys will just caught the stream late. You can watch the whole thing and then scan it, and but it will expire by late tonight and tomorrow. So use the CBD MCQ module or the registration link to claim your points. Okay, so yeah, Casey, yeah, great session. Thank you. I'm sure all of us appreciate. We can give you a virtual round of applause, Chris. It was a
My
marathon
pleasure. Thank you
session.
very much.
Yeah, yeah. So I want to wish everybody good night. Have a good rest of the week ahead. And thank you once again for taking part. We have another session next week on Saturday. That's an SGMC Grand Round. So please catch that and you go to the docs.my website to see all our upcoming coming CPDs. So we have at least two every week, every month for you guys. Huh? So two per month times 10 months, it's your mandatory 20 points. You just follow us is good enough. All right, good night and take
Good
care.
night.